Chapter 11 Appointment and Qualifications of Directors Company to have Board of Directors 149. 1. Every company shall have a board of directors consisting of individuals as directors and shall have a minimum number of 3 directors in the case of a public company, 2 directors in the case of a private company, and 1 director in the case of a one-person company, and 3b, a maximum of 15 directors, provided that a company may appoint more than 15 directors after passing a special resolution. 8. Provided further that such class or classes of companies as may be prescribed shall have at least 1 woman director. 2. Every company existing on or before the date of commencement of this Act shall within 1 year from such commencement comply with the requirements of the provisions of subsection 1. 7 and 9. 3. Every company shall have at least 1 director who has stayed in India for a total period of not less than 182 days in the previous calendar year. 2 and 6. 4. Every listed public company shall have at least 1/3 of the total number of directors as independent directors, and the central government may prescribe the minimum number of independent directors in case of any class or classes of public companies. Explanation. For the purposes of this subsection, any fraction contained in such 1/3 number shall be rounded off as 1. 5. Every company existing on or before the date of commencement of this Act shall, within 1 year from such commencement or from the date of notification of the rules in this regard as may be applicable, comply with the requirements of the provisions of subsection 4. 6. An independent director in relation to a company means a director other than a managing director or a whole-time director or a nominee director. 4a. Who, in the opinion of the board, is a person of integrity and possesses relevant expertise and experience. b. Who is or was not a promoter of the company or its holding, subsidiary or associate company. 2. Who is not related to promoters or directors in the company, its holding, subsidiary or associate company. 5c. Who has or had no pecuniary relationship with the company, its holding, subsidiary or associate company, or their promoters, or directors, during the 2 immediately preceding financial years or during the current financial year. d. None of whose relatives has or had pecuniary relationship or transaction with the company, its holding, subsidiary or associate company, or their promoters, or directors, amounting to 2%. or more of its gross turnover or total income, or 50 lakh rupees or such higher amount as may be prescribed, whichever is lower, during the 2 immediately preceding financial years or during the current financial year. Who, neither himself nor any of his relatives, holds or has held the position of a key managerial personnel or is or has been employee of the company or its holding, subsidiary or associate company in any of the 3 financial years immediately preceding the financial year in which he is proposed to be appointed. 2. Is or has been an employee or proprietor or a partner in any of the 3 financial years immediately preceding the financial year in which he is proposed to be appointed. Of a firm of auditors or company secretaries in practice or cost auditors of the company or its holding, subsidiary or associate company, or b. any legal or consulting firm that has or had any transaction with the company, its holding, subsidiary or associate company amounting to 10% or more of the gross turnover of such firm. 3. Holds together with his relatives 2% or more of the total voting power of the company, or 4. Is a chief executive or director, by whatever name called, of any non-profit organization that receives 25% or more of its receipts from the company, any of its promoters, directors or its holding, subsidiary or associate company, or that holds 2% or more of the total voting power of the company, or f. who possesses such other qualifications as may be prescribed. 7. Every independent director shall at the first meeting of the board in which he participates as a director, and thereafter at the first meeting of the board in every financial year or whenever there is any change in the circumstances which may affect his status as an independent director, give a declaration that he meets the criteria of independence as provided in subsection 6. Explanation. For the purposes of this section, nominee director means a director nominated by any financial institution in pursuance of the provisions of any law for the time being in force, or of any agreement, or appointed by any government, or any other person to represent its interests. 8. The company and independent directors shall abide by the provisions specified in Schedule 4. 9. Notwithstanding anything contained in any other provision of this Act, but subject to the provisions of Sections 197 and 198, an independent director shall not be entitled to any stock option and may receive remuneration by way of fee provided under subsection 5 of Section 197, reimbursement of expenses for participation in the board and other meetings and profit-related commission as may be approved by the members. 10. Subject to the provisions of Section 152, an independent director shall hold office for a term up to 5 consecutive years on the board of a company, but shall be eligible for reappointment on passing of a special resolution by the company and disclosure of such appointment in the board's report. 11. Notwithstanding anything contained in subsection 10, no independent director shall hold office for more than 2 consecutive terms, but such independent director shall be eligible for appointment after the expiration of 3 years of ceasing to become an independent director, provided that an independent director shall not, during the said period of 3 years, be appointed in or be associated with the company in any other capacity, either directly or indirectly. Explanation. For the purposes of subsections 10 and 11, any tenure of an independent director on the date of commencement of this Act shall not be counted as a term under those subsections. 12. Notwithstanding anything contained in this Act, 2 and 6I, an independent director, and 2, a non-executive director not being promoter or key managerial personnel, shall be held liable, only in respect of such acts of omission or commission by a company which had occurred with his knowledge, attributable through board processes, and with his consent or connivance, or where he had not acted diligently. 2 and 613. The provisions of subsections 6 and 7 of Section 152 in respect of retirement of directors by rotation shall not be applicable to appointment of independent directors, exceptions/modifications/adaptations. 1. In case of Section 8 Company, Section 149, 1, and the first proviso to subsection 1, shall not apply. Notification dated 5th of June, 2015. 2. In case of Section 8 Company, subsections 4, 5, 6, 7, 8, 9, 10, 11, Clause I of subsection 12 and subsection 13 of Section 149 shall not apply. Notification dated 5th of June, 2015. 3. In case of Government Company, Section 149 1b, and the first proviso to subsection 1, shall not apply. Notification dated 5th of June, 2015. 4. In case of Government Company, in Clause A of subsection 6 of Section 149, for the word board, the words Ministry or Department of the Central Government which is administratively in charge of the company, or, as the case may be, the state government shall be substituted. Notification dated 5th of June, 2015. 5. In case of Government Company, Clause C of subsection 6 shall not apply. Notification dated 5th of June, 2015. 6. In case of specified IFSC Public Company, subsections 4, 2, 11, Clause I of subsection 12 and subsection 13 of Section 149 shall not apply. Notification dated 4th of January 2017. 7. In case of specified IFSC Public Company, subsection 3 of Section 149, the following proviso shall be inserted, namely: provided that this subsection shall apply to a specified IFSC public company in respect of financial years other than the first financial year from the date of its incorporation. Notification dated 4th of January 2017. 8. In case of specified IFSC public company, second proviso to subsection 1 of Section 149 shall not apply. Notification dated 4th of January 2017. 9. In case of specified IFSC private company, subsection 3 of Section 149, the following proviso shall be inserted, namely: provided that this subsection shall apply to a specified IFSC private company in respect of financial years other than the first financial year from the date of its incorporation. Notification dated 4th of January 2017.